2026. And for this special interview series on T-minus retirement, I had the opportunity to sit down over a call with Mike Bennett. Mike is a former attorney specializing in estate planning and taxes. And he's one of the co-founders of a company known as Encorestate Plans. Now, Encorestate Plans provides back office living trust and estate planning assistance for financial advisors. They don't work directly with consumers, but with licensed advisors. And so we utilize their services to help our clients with putting together living trusts as part of their estate plan. And this interview is really geared to help answer questions about why have a living trust, what it is, what it's not, some of the bullet points to think about if you have maybe an older one that hasn't been amended recently, especially prior to 2020, 2021. I think if you're in that kind of net worth range of 1 to 14 million or so, 1 to 15 million, and you're especially if you're in California, as part of our conversation is around Prop 19 for a moment. You'll find this bullet pointed information pretty helpful. One of the points that Mike makes that's incredibly useful is that you can still find good information out there if you just need some information as to why when it comes to a living trust, and if it's going to be able to help you in your situation. Ultimately, it's about having a living trust is not necessarily about evading taxes, but it's really about helping make an easy transfer, an easy administration of your assets, your wealth to the next generation or whatever charities you want to have it. And so we talk about that and what that is and what that does. And so I hope you find this interview helpful. It's important, though, to note that this is not official legal advice or financial advice for you in your particular situation. This is just information. If you do have a situation where you want to ask about that, I do encourage you to reach out to your financial advisor, your financial professional, or your attorney. Here at Team Wealth and Tax Advisors, we can help and assist with putting together a living trust. Although we ourselves don't provide legal advice. If you want to learn more about our services, whether it's around financial planning or putting together a living trust, you can look us up online at www.wealthandtax.com. But I hope that you enjoy this as you sit back, listen, or watch it. Have a great day. I'm Brian Owen. I've got on the call with me this morning, I have Mike Bennett, who is part of one of the founders with Encorestate Plans. And we wanted to bring to everybody a brief conversation, but a helpful one on the subject of living trusts and their significance when it comes to wealth management, when it comes to legacy planning, and something that you tend to think more about as you get into retirement planning, or, as your family grows and increases and you want to be able to make sure that everyone's taken care of and that none of your assets are going to have to go through any messy process and being transferred once you're gone. So, Mike, thank you for joining us today. I really appreciate it.
Yeah, thank you, Brian. You know me, I always love to talk estate planning. So
yes,
let's do it.
Absolutely. And yes, our firm at Team Wealth and Tax Advisors, we utilize your firm's services with Encorestate Plans. And as you said before, it's our back office estate planning service, and we're super appreciative. But if you don't mind, just give me a couple minutes on your background and how you got to the point of starting Encorestate Plans.
So I didn't realize how fortunate I was at a young age to find something that I wanted to do and loved to do. I knew even before I went to college that I wanted to be in tax and estate planning or be a sports agent. But that's when I realized that wasn't going to happen. Tax and estate planning was always the way I wanted to go. So everything I did, I went to UC Santa Barbara. I got the business econ degree, emphasis in accounting. Moved back up to Northern California for law school. Got my tax concentration, and I've done nothing but estate planning since I graduated from law school. I'm a recovering attorney now, so I'm not currently an attorney, but it's literally all I've ever done. For over the past 20 years, and just absolutely love it. With Encore, we just decided to instead of having something regional, to have something nationwide. And so, but the biggest concentration of our advisors is in California. So, and I happen to be in California, so it's it all works out really well.
Yeah, as do I. Our firm is in Temecula Valley, and we're in Southern California's wine region. And I know we were chuckling before our call this morning about differences in Northern California and Southern California when it comes to Napa Valley versus Temecula, but. Nonetheless, we have clientele all over the state, and all like you're talking about with Encore, all over the country too, and some that are even international. So
Estate planning and taxes doesn't elude anybody, or doesn't evade anybody, I should say.
That's right.
Yep. Well, that's exciting. So you basically are in the world of estate planning and taxes, and one of the things that I find is very, very helpful is on the subject of understanding, sometimes when you mention having a living trust, or, especially in the context of folks who are kind of in that net worth range of be it 1 to 5 million or 1 to 10 million, sometimes without much education, a trust is viewed as this magic vehicle that somehow helps hide everything, and even to the point of taxes. And so can you kind of share with us, what are kind of the main things to consider with a living trust? And, how do we kind of like separate that idea of like, hey, it's there to transfer wealth, but at the same time, it's not there necessarily to evade taxes.
Right. And so if I could boil trust-based estate planning down to one word, that word is control. And that's something we go back to constantly. You're controlling who gets it, how they get it, who makes financial decisions, who makes healthcare decisions, who's the guardian of minor kids. In California in particular, it's the other part of that control is control over like administrative expenses. So living trust-based estate planning is the most common way to try to avoid probate. Probate is just the legal transfer of assets when somebody dies, and a lot of people don't like probate for 3 reasons. 1, it's way too expensive. 2, it takes too much time. And 3, it's public. And so you're doing a public court proceeding when you're going through probate. Whereas for trusts, if you do things right, and that's a big if you do things right, you make sure everything's properly funded, you can avoid any type of public court proceeding. It's a little bit more private, but it's not like this magic bullet where, nobody's going to be able to see who owns your home or, something like that. And it also, from an income tax standpoint, it's pretty tax neutral, and you don't just get to put things in your trust and avoid all liability either. That's a common misconception when it comes to revocable trust-based estate planning.
That's a very good point. On that subject of when you consider revocable trust estate planning, there's a lot of jumbling of the words, or a lot of jargon being moved around. Like, is it estate tax? Is there an inheritance tax? Is there what kind of taxes am I dealing with, or should I be concerned about? What are some of those different tax situations that folks should be in? If they're in the net worth range of, say, 1 to 10 million, including their residence, what are some of the tax implications they should be aware of?
Yeah, so income tax, that's just your standard, you file your, annual income taxes if you're required to, and there's that. State taxes is a whole different animal and just doesn't affect that many people anymore. There's a federal estate tax exemption amount of $15 million per person. I joke that I hope that you have an estate tax issue because that means you're worth quite a bit. California does not have a state tax or inheritance tax. You don't get taxed on money that you inherit unless it's through a qualified account like an IRA. If that money wasn't taxed to the person who you're inheriting it from, then yes, you'll be taxed on it as you pull that money out, like in an IRA. But for the most part, if you inherit a home, if you inherit stocks, those types of things, you're not taxed by getting that by receiving that. So there's a common misconception on that front that you're going to be taxed. And then in California, we have a third tax implication that we need to deal with, and that's property taxes. And so but that only applies to real estate, and we can dive into that if necessary.
Sure. Yeah, no, that's a very good point. It seems to be, and let me know if otherwise, but it seems to be that when you're in that range of, say, you're under the 15 million threshold, it seems to be that most of your concern ends up being around say income oriented tax, or even gains tax, capital gains.
Yeah. And that's and when someone does die, we do get that step up in basis for determining capital gains. So if you bought a home for $100,000 and it's worth $700,000 today, you pass away, your kids sell it, it's as if they paid $700,000 for that piece of property. It's just a very basic example.
Yeah, and those step ups incredibly helpful. And I understand too. And we've seen this actually as financial advisors. There's some people have asked us about the small estate exemption that because that's something that they should consier. Have you had anybody talk with you about how that works, or if that should be done outside of the trust?
So you're talking about just for any account in California, it's around $200,000 now. I think it's gone up, and it's gone up quite a bit since I first started. But I think it was $100,000 when I first started, and now it's up in the $200,000 range. But anything that is any probatable assets, if it's under that amount, you're not going to have a full-blown probate, and you qualify for what's called a small estate affidavit under 13100 of the California Probate Code. And ultimately what that means is that 40 days after death, your heirs could go and get a bank account that was left outside the trust, for instance. And when I say probatable assets, there's three categories of assets that are not probatable. Yeah. One is assets with a beneficiary designation. So like if you have a life insurance policy that pays out to a named beneficiary, that doesn't count. Assets that are held jointly. So for like if you and I have an account together, I pass away, you just get that account. That doesn't go towards that $200,000 number. And then the third category is the assets held in trust. So that's, so anything under that, it's easy to get. There's no full-on court proceeding, but it can be a little bit of a headache. But I do recognize that it is common to kind of leave like a checking account outside the trust and stuff like that.
Yeah, no, absolutely. And kind of what you're talking about, even with the headache that's involved, in dealing with these different forms and these different procedures, those are part of one of the significant reasons when we talk about easily administering or carrying out the transfer of wealth or conveyance from one generation to the next. That's really where having those assets that are, be it titled in trust or, like you mentioned, joint tenants or designated beneficiaries. That's where it really helps to have those easily administered when it comes time to transfer.
Yeah, absolutely. And ultimately, I have clients who've told me in the past when I was in private practice, what do I care? I'll be dead. And, and it's like, okay, I get that. But I mean, there's really only four places that your assets can go when you're gone. Two of them are good. Two of them are bad. Two of them are your individual beneficiaries and your charitable beneficiaries. We want that. Yeah. And then the other two are to administrative expenses and to taxes. And so we kind of want to minimize those. You don't want to have a probate court involved, attorneys involved. I mean, you may need those things, but you want to minimize those to the extent possible. And so it's, what do I care? I'll be dead. Okay, yeah. And they're mostly joking when they say that, but I definitely want to point out, who would you rather have it? Yeah. Definitely those first two.
Well, it's in the financial planning arena or in the tax planning arena. It's funny because we've heard some people say oh, I don't care. I want my last check to bounce when I'm gone.
Yeah. So good luck.
Yeah.
Good luck.
Yeah. So having a living trust is especially in California is absolutely important if you want to make sure that the ones you care about, or even if you don't have any necessarily immediate next of kin or next generation, maybe there's a charity you care about. Having a trust is super important to be able to help ease that transfer process. One of the common areas we've heard from people or have been asked about is hey, I got my trust done back in 2000 or 2001 or in 1997. It hasn't been updated, but I haven't had that many family changes. Do I need to have it, updated?
So what would you say to that? Annoying answer. I'll give you an annoying answer, but I promise I'll expand on it. My annoying answer is always, it depends.
You're a recovering attorney, I understand.
Yeah, I can't help myself. And so I'd like to say that if you or anybody associated with your estate plan has had a significant change in health or wealth, it's a good time to look at the plan. With that said, even if you haven't, a good rule of thumb is approximately every 5 years or so. If you don't feel like you've had any of those changes, I mean, when I hear you say 2000 or 1997, the estate tax exemption amount in 2000 was $1 million. Yeah. And so it was a different type of trust planning that we did then versus what we do now. There's much more flexible trust structures now that, and I mean, I can go into the details, but it's the trusts. Generally speaking, the trusts that we do now are much more flexible for the surviving spouse if the circumstances call for that. But man, there's a good chance that if you did that when your kids were younger, maybe now you're looking for your kids to be your successor trustee if it's been that long. Or maybe on the flip side, maybe your kids then are spinning their wheels now where they should never have control of their assets. So there's so many different things that you can point to that especially on a trust that old. Whether it's a structure or just the decisions that go into that.
Yeah, that's a very good observation, and that's a good summary of points. These things do change. Rules, exemptions change, laws change. These things. Right. What would you say is a normal term, just to maintain a good living trust? What's a good period of time to update it? How often should that be?
And again, it's unfortunate. It depends, but it's. I mean, it's 3 to 5 years, is the most common numbers that I hear. But again, I have 2 minor kids. When my wife and I first did our trust in 2008, we didn't have kids. And so I will tell you that from my experience, the most common thing that we've updated in the 18 years we've had a trust is the guardians for our minor kids. It started with grandparents, then it went to siblings. Now it's a mixture of siblings and dear family friends and, stuff like that.
Wow.
And so that's just one example. I mean, but if you have kids who were, when you did your trust, that were in their teens, there's no way you left them all their money at 18 at that point. And so now maybe those kids are in their mid to late 20s. They're responsible adults, and you're thinking about them as successor trustees. So it's the time frame. The time frame is less relevant than life. Life changes, and life's always going to be complicated. And so and what's the downside of having it checked out? Nothing.
Yeah.
Nothing. You feel good about it. You're like, oh wow, it's exactly what I wanted to say. That's amazing.
Exactly. You're completely right. I think people sometimes have a natural hesitancy because they're concerned about like, oh, what's it going to cost me to update it? What's it going to cost me to change it? And always have to reframe the question. Well, think about think about the wealth you've built up, or the ones you care about. What's it going to cost you not to update?
Right. I mean, if you have a successor trustee who can't manage their own money, why should they be managing yours? And then one other point that I didn't hit on is making sure your assets and your beneficiary designations are properly in line with your trust. Did you sell your house and then move into another house? Did you put that house in the name of your trust? Are the beneficiary designations? We had one recently where the person had been divorced for 6 years, never changed the beneficiary designations on his IRA, still had his ex-wife on there. And if something would have happened to him, that money's going to the ex-wife. And I mean, that's a huge problem.
Yeah. We, as people, we tend to have the type of biases that we operate so much on assumption without seeking out good advice on how like you said, life is dynamic, it changes, it's not static, and it's necessary to get good advice and counsel sometimes on what do I do in these situations? How do I adapt to this, or what do I need to update?
Yeah, or even just good information. I mean, they don't even need legal advice a lot of times to do it. You just need someone who's going to sit there and uncover the issues, and then, oh wow, we've uncovered this issue. Now we can actually do something about it because we know about this issue. It's huge.
Very good point. I know it's commonly discussed right now, and you're not new in the world of technology advancement. When it comes to finding good information, have you found, what has been your experience with like people using, whether it's just simply a Google search or taking it a step further to Gemini or Chat GPT? Have you found from your own experience or your involvement with others that like, hey, is there one that's more reliable than the other, or how do you, when you want good information, where do you start?
So our firm, we did a whole study on AI where we put 50 questions of varying degrees of complexity into four of the top AI, the AI models. And for the basic questions, it's pretty good. But what's basic? But as they became more nuanced and like needed a little bit more context, they became not so good. I guess what I'll say. What I've always compared AI to, or not always. It's not like it's been around that long. But like it's what I've always compared it to is like a first-year attorney or a second-year attorney or a first-year financial planner who want to just go out and show everything they know, and they don't want to say, 3 little words. I don't know. It's powerful to use that word, to use that term, and because you can go get those answers. I does not want to say I don't know. And we've tried to do things in AI where we've embraced it at Encore. We absolutely have, but we joke that we have a lot of people who we work with that have gone to Chat GPT law school, and it's it's one of those things where like, oh great, and they'll look up something and say, well, this is what I want the documents to say, and there'll be one provision that sounds really good, and then there'll be a provision right afterwards that literally contradicts what is said in the previous paragraph. But okay, and we put some of our own stuff into AI where it said, hey, no, this is way too detailed, or this is way too restrictive for a power of attorney to do. Well, then we strip out the language that it says to strip out. We go and put it in the exact same AI model, and it'll say, well, God, there's not really enough restrictions on here on the power of attorney. And say, well, wait a second, like you can't have it both ways. And so and that's where I feel like the sweet spot is to embrace the technology, but don't exclusively rely on it. That's where you come in, Brian. That's where we come in. It's to use that technology and then have that context and have that human involved to get you to get a client to the right place, to get the perfect information so they can make a great decision on their estate plan.
Yes, which is absolutely essential. On a common set of questions that, or I should say a common topic that we deal with from clients is the subject of real estate and being able to transfer it, especially in California here, where sometimes, again, going back to jumbling, like whether it's tax implications, step up in basis, Prop 19, what did that do for it? I know you have some knowledge there. So if you don't mind, kind of just summarize for us, share with us, like what should a homeowner be aware of, and when it comes to that?
Yeah, so we'll get to Prop 19, but I mean, just fundamentally, the California probate system. If you have a $1 million house in California with a $500,000 mortgage, when you and I look at each other, we do simple math and say that's a $500,000 asset. When it comes to probate, attorney's fees and executor fees are all based on that gross value, that $1 million. And so $1 million probate in California is $23,000 in attorney's fees, $23,000 for the executor, and about $4,000 to $5,000 in court costs. So that's, and sometimes the executor is a family member who's not going to take their fee. I can guarantee you the attorney's going to take their fee. But that's up to $50,000 coming out the top. So let's say we've done it all right and you got everything in there where it's where you're avoiding that probate. That's great. Now it comes time, you've passed away, and it comes time for the kids to decide whether or not to sell that house. And let's say that $1 million home you bought for $300,000 way back when. Not unheard of in California.
Oh yeah.
So when it comes to that, we've alluded to the step up in basis. So if the kids do sell, it's going to be as if it's worth $1 million. And so they would pay any capital gains on anything over and above that. Property taxes is a whole different animal. Up until 2021, backing up just a little bit, Prop 13, the property taxes that that homeowner was paying was based on that $300,000 number in this example. And it's steadily gone up 2% a year until there's a change of ownership. Well, at death, that can be considered a change of ownership. For property tax purposes, up until February 15th, 2021, there was something called the parent-child exclusion from property tax reassessment. So you could pass that home down to your kids and they get to retain your property tax figure. Huge if they wanted to rent it out. And so like that, that changes the math. Nowadays, that parent-child exclusion since February of 2021, that parent-child exclusion has become significantly reduced. It's now only valid if one of those kids is going to take it as their principal residence. And so that is a huge thing. So now if these kids want to rent it out, well, it's clearly not their principal residence. Their property taxes are going to jump up to that, be based off that $1 million number.
Yes.
That changes the math on when it comes to whether or not you want to sell or whether you want to rent. And so I think that's where you want to ultimately go with that. Sorry for all that background there, but I want to set that stage for where we're going there.
Yeah, no, I appreciate that because that's very, very important because the property tax issue, again, people sometimes without knowing too much, it's easy to think, oh, the living trust is going to somehow help me, or the trust is going to help me somehow, avoid all this or, be the magic covering to deal with it for me.
Yeah, I wish. Yeah. And when I was in private practice, I would have clients who would ask like, okay, well, what if we just leave it in mom and dad's trust? They'll never know. Maybe, but probably not. Eventually they're going to know. And then that reassessment date is going to go back to the date of death, not to the date that you actually transferred things. And you'll have interest and penalties for not paying all those property taxes that were due all the way through there. So
exactly. Yeah. No, you have it's a great point because it's important to understand that, hey, a trust is for the easy administration and transfer. It's not necessarily to avoid the taxes. Those are two separate paths we're dealing with when it comes to the taxable implications versus the transfer or probate implications.
Yeah, absolutely.
Yeah. So that's really helpful, Mike. I thank you for sharing that background with us. I know I myself, I like the background information. It helps me kind of understand, how we got to where we are now. So on the subject of a good living trust, kind of going back to that, what should a good, thorough living trust include in it? What elements should be included in it?
So I like to call it a living trust based estate, and because the living trust is the major component of that, and that's your foundation. But then you have all these other documents around it that make it a plan. You have a financial power of attorney. And that helps govern your non-trust assets like retirement accounts. You have advanced healthcare directives, so to state who's going to make healthcare decisions in the event you cannot. You have pour-over wills, so it surprises a lot of people that you have a will even when you have a trust. I mean, the will in California just names guardians for your minor kids, and it's really just a backup document. It's called a pour-over will because everything pours over into the trust. That's the beneficiary of the will. And then you have a bunch of other little documents as well, certification of trusts, general transfers, HIPAA releases that make it a whole plan. And the whole goal is to govern not only what happens when you're dead, but I think it's underrated to govern what happens if you become incapacitated.
Yes, that's a very good point. I've often explained to clients that, when we're establishing a good estate plan that includes a living trust, we have to view life as the timeline. And that includes the point of, hey, we're of sound mind now, we're functioning, we're making decisions. There comes a point when we may be unable to or incapacitated, and that's where having that piece of the trust picture, if you will, the power of attorney and the medical wishes and all of that, that directives, that's where all of that is essential to be able to make sure that there's no kind of unfilled gap in our timeline of how we, who makes decisions for us and what happens with the things we have.
Yeah, absolutely. It all comes down to that one word, control. You get to control it.
Yep. And that's a great way to summarize the benefits of it. One other topic on this, and some folks have asked me recently, hey, I have some assets that are a little unconventional. I have some digital assets, maybe a digital wallet, like a Bitcoin wallet, or, an online account somewhere else. I mean, aside from the fact that, as we talked about earlier, if you can designate a beneficiary, then, or if there's a joint tenancy, then okay, great. That's you're taking care of that. But still, how should folks, include, digital account or online accounts, digital assets, things that are a little less conventional than what they're used to normally including in their planning?
Yeah. So for as tech forward as a lot of those things are, whether it's like your Bitcoin or those types of things, it's all very tech forward, but the estate planning ramifications of those things are behind the times currently. There's not many of those types of wallets and stuff like that where you can name a beneficiary, where you can have a joint owner on them, or put them directly into your trust like you would a bank account or a piece of real estate. And so it has some catching up to do. I have every faith that it will, but until then, you have to plan as if it can't be. So the way that we currently deal with something like that is, we always have language in the trust, even though it's not a trust asset at this point, that helps deal with digital assets. But in your financial power of attorney is where you can help govern, where you can say, oh no, I want my power of attorney to be able to get access to these things. And my will makes reference to digital assets as well, and says just give them all to my trust, those types of things. So you have these three documents, the power of attorney, the will, and the trust, working together to make sure that somebody can access those things when you're gone and has the legal authority to do so. So we're ready for it now if something happens to a client, but we're hoping that things kind of get up to the time so it won't be. And so I guess that's also my long-winded way of saying it depends, but it's I am amazed by how much catch-up it needs to do in the estate planning world for those wave of the future type assets.
Yeah, those are good points, and it is something that folks, if they have them, they got to think about that. Sure, maybe there's not a formal process, but I at least need to make sure that who I'd want to be my power of attorney is able to actually access these. So that's right. I think that the Exhibit A list of assets held, when we're putting a living trust together, it's like making sure that we list out everything.
Yeah, and that's just giving your successor trustee a fighting shot at finding everything. And so because if it's not your spouse or something like that, how are they going to know where your wallet is, your online wallet? And so just being able to direct them is huge.
Absolutely. So one more topic for conversation here is, putting a living trust together is a fairly simple process. There's obviously tools to do that. And obviously you can work with folks out there can work with either attorneys or advisors who work with back office estate planning services like Encore. When does somebody need to consider, say, okay, I can go and get this done in a semi-automated fashion or in a short order fashion? for a standard living trust, when does somebody need to consider, say, hey, I need to maybe look at one of those other fancy, irrevocable type of trusts, or those other, the endless,
Yeah.
not acronyms, but, initialized types of trust names. When does somebody need to like take that step into something more complicated?
So the most common time is when you're pushing up against the estate tax exemption. When you're trying to get assets outside of your taxable estate for estate tax purposes, far and away the most common. But with the estate tax exemption amounts being where they are, that doesn't drive a lot of people. I will sometimes see people with businesses that are looking, to do, maybe they're going to have a huge liquidity event or something like that. Maybe they're considering things like that. But it's, I mean, that I'm in the estate planning software space, but I'll be the first person to tell you that estate planning software is not for everybody. It's for, it's for someone who, you can always, going to your local estate planning attorney is always going to be an option, and it should always be an option. And, because doing something strictly online, though, with no help at all, that scares a lot of people as well. And so we've tried to bridge that gap with you guys and with us to like, no, let's get all the good information out there, have attorney level quality documents. But you and I both know that we're not going to be the fit for everybody. And, and so you'll see, so the estate tax exemption is one thing. And I guess on the other end of the spectrum, I don't do any of this type of work, but, there's a lot of stuff out there about like Medicaid or, for California, it's Medi-Cal. Type planning. And I think that that's largely overused. And I think it's often used as a scare tactic to try to, you got to do this. It's right. Like everything. It's right for certain situations. It's not right for everybody.
Yes. That's a good point. It's very, very helpful. And I know, for those of us those listening to this podcast or watching, those may be some questions that you're coming up with, or maybe you have had a trust done and it's been a while since it's been updated. Mike, if there's like maybe a couple points that someone listening should take away from this, and they're in that situation, maybe they've never visited setting up a trust, or they haven't done it, they haven't revisited it in a long time. Maybe give them like, a couple points, like what should they do? What should they consider doing now? What should be like the immediate concern or plan of action?
So for those who don't have a plan, the points I like to stress are, you need one. But I think there's a lot of procrastination around this. And the point that I want everybody to hear is that it has never been easier to get a set of high quality estate planning documents. It's not going to be as hard as you think it's going to be. I already outlined the 5 major decisions: who's getting it, how are they getting it, financial decisions, healthcare decisions, and guardian and minor kids. I realize those aren't easy to talk about, but those are the major decisions. For those of you who have a plan, I think the takeaways are, it's always good to review it to make sure it says what you want it to say. And then just as importantly, make sure that your assets and your beneficiary designations are in line with what you want. If your beneficiary designations say one thing, but your estate plan says another thing, there's a big disconnect.
Yeah. That's a very good point. Well, Mike, I really appreciate your time. This has been very helpful, and also pretty bullet pointed. It's pretty, this is good advice, and there's good pieces and segments here that I know will be a benefit to listeners. I know if somebody you're with Encore Estate Plans, what's your website address in case anybody wants to check out Encore?
Yeah, it's EncoreEstatePlans.com, and that's Encore and Estate. It's there's a charity in the middle there, so that always gets people. But yeah, EncoreEstatePlans.com. But yeah, it's we're exclusively for financial advisors. We're not a direct to public offering, but it's something where we like to make sure that we connecting financial advisors to their clients in a significant way. That's what we're trying to do with Encore.
Well, we appreciate it. As here at Team Wealth and Tax Advisors, where we utilize your services and your team's services, it's been incredibly helpful for our clients, incredibly helpful for us. And so, if you're listening to this and you don't have a financial advisor who is part of and has an estate planning effort, definitely something to consider. And if you're in that more complex, higher net worth space, like Mike, like you're saying, where you're pushing up against that exemption, that's where you do need to be speaking to an attorney. But hopefully by then you already are. So. those are just good things to prepare for.
Perfect. No, I love working with you guys. So yeah, happy to answer any other questions that come up as a part of this too.
I appreciate that, Mike. You've been very helpful. Everyone, thank you for tuning in for this and listening. Hope this was helpful. If you have any questions, you can always reach out to us at wealthandtax.com, where our contact form and information is. And, stay tuned. Well, as we have more interviews and more helpful information that we can give out there to make your financial planning efforts and estate planning efforts a little bit easier. So, Mike, again, thank you for your time.
Thank you, Brian.